Hi everyone, thank you for joining the session. We're just going to give it a few minutes while everyone starts to come through. I can see you're all starting to join now, so we'll just give it a minute while everyone continues to join, and we'll get started shortly. I think we've just got a few more coming through, so let's give it a few more seconds, and we should be able to start in a few seconds. Right, I think everyone looks like they've joined, so we'll get started. Hi everyone, my name's Tegan. I'm the course advisor for Healthcare Ethics and Law, and thank you for joining us today for this session. I'm joined by two special guests who will introduce themselves shortly, and we'll be able to take you through the session today. So to begin with, obviously we'll just do some general introductions. We'll then be looking at healthcare scandals and the criminal law, and there will be time for some audience Q&A. So that's where you'll get the chance to ask any questions that you do have. Any questions that you do have, please do pop them in the Q&A or in the chat, and we'll try to get through as many questions as we can. So please do that. You can do that at the end, or you can pop them through throughout the session if it's easier, so that you don't forget the question that you have. We will then also do a brief course overview to go through some of our healthcare ethics or online courses, and then we'll share some information on how to contact us. Okay, so without further ado, we're joined by Professor Sarah Devaney and Dr. Alexandra Mullock, so I will hand over to them to introduce themselves.
Thanks very much, Tegan. And thank you to everyone who's joining us today. We're really grateful that you're giving us your time. My name's Sarah Devaney. I am one of the co-directors of the Centre for Social Ethics and Policy, together with Alex, who is presenting today as well. And that is the research centre in the Department of Law at the University of Manchester that runs the distance learning programme on healthcare ethics and law. We also have a campus-based programme that is equivalent to this, that people can attend full or part-time. But today we're focusing on the distance learning programme, of which I am a graduate myself. I studied for that course while I was a solicitor in practice a lifetime ago. So I'm more than happy to answer questions at the end about that. I'll hand over to Alex to introduce herself before I set us up for the presentation we're doing today. Oh, you need to take yourself off mute, Alex.
There we go. So I'm Alex Mullock, and as Sarah said, I am one of the co-directors of the Centre for Social Ethics and Policy, and I've been teaching at Manchester for many years now. And today the intention is just to give you a taster of some of the work that Sarah and I are doing, and give you a flavour of the sorts of issues you would be studying if you come and join our distance learning programme. So with that, I think we'll begin. If we can have the next slide, please, Tegan. So Sarah and I, over the years, have looked at a variety of topics that touch upon the kind of intersection between criminal law and medical law. And so, for example, one of the areas that I've done quite a bit of work on is assisted dying. And I also was part of a project a few years ago that looked at the impact of the criminal law on healthcare ethics and practice. And from that came my interest in how criminal law responds when things go very seriously wrong within healthcare. And we've particularly become interested in the role of scandals in shaping the law, because As a response to various scandals over the years, the law reacts and can react in a variety of ways. And one of the ways it can react is by kind of expanding the reach of the criminal law. So we're particularly interested in the way that the law has responded over the years, and particularly about the role of gross negligence manslaughter when healthcare professionals make very serious mistakes leading to the death of a patient. But we're also interested in non-fatal and deliberate harm to patients. And so I'll be talking briefly about rogue surgeons or bad apple surgeons with a couple of cases that you might have heard about. Then Sarah will be talking about corporate manslaughter and how that can be used as a response to this type of harm within healthcare. So next slide, please, Tegan. So as I said, healthcare scandal can be a driver for legal change, and we've seen various examples of this over the years. So for example, the trial and prosecution of Dr. Harold Shipman led to changes in coronial law and increased regulation of doctors that some of you may be all too aware of. The organ retention scandal, Alderhay and also Bristol Hospital, where the organs of children and tissue from deceased patients was retained and kept without the consent of the family, which led to changes to the law on how human tissue is governed and controlled. And then Stafford Hospital scandal a few years ago led to an inquiry, which then led to changes in the law. So you might have heard, obviously, of the duty of candor, which was one of the changes, but obviously that's not within the criminal law. But it also led to new criminal offences, ill treatment and willful neglect. So they're just a few examples. Next slide, please, Tegan. So we've got some images here of some very high-profile murderers and a couple of sex offenders there on the right with the gentleman who you might not recognise, but those two are GPs who were just in the past few months convicted of a serious sexual assault against patients. And interestingly, sexual offences or sexual misconduct, even not amounting to criminal prosecutions, are the key reason for doctors being erased from the medical register. But then the pictures on the left are far more recognisable. We have a picture of Harold Shipman, who was convicted of murdering 15 of his patients, but it's thought, in fact, that he was responsible for murdering well over 200 patients. And then we also have pictures of nurses Beverly Ellett, who was convicted of murdering several children in the 1990s and also convicted for attempted murder. And then the bottom picture is a more recent case with the conviction of nurse Lucy Letby for the murder of many babies, and notwithstanding that, obviously many people think there's a big question mark over her conviction and possible miscarriage of justice, but I'm not going to comment on that. So next slide, please. So specific offences that exist or have existed for quite a long while in relation to activity within medical practice that might amount to a criminal offence can also be seen. So, for example, there's been quite a lot of attention recently about women who've been prosecuted under the Offences Against the Person Act for procuring their own miscarriage. And that is an area where we've seen more activity in recent years. So that's just one example. Also, there's a criminal offence now under the Human Tissue Act 2004 for taking organs or human tissue without consent. And there is also potential criminal liability for activity in relation to fertility treatments outside the licensing conditions under the Human Fertilisation and Embryology Acts. Next slide, please, Tegan. But one area where we have seen many prosecutions over the last few decades is in relation to gross negligence manslaughter, where this is an offence that's quite unusual within the criminal code because it can be used to capture serious error that causes death, including culpable omissions, which is quite rare in the criminal law. And so it's particularly interesting in relation to how this has been used in healthcare. So this is a long-standing offence. There's an example there from 1925 when a doctor was acquitted after he was prosecuted for causing the death of a woman giving birth because of the very poor standard of care that was demonstrated. Next slide, please. Tegan. And this particular offence has led to lots of anxiety and also lots of criticism about the way it's used, particularly in relation to healthcare professionals. And it's been subject to a couple of reviews by the Law Commission in the 1990s and more recently in 2006, where it's been criticised because of the kind of low level of fault needed to establish liability when something goes wrong in a caring situation such as a healthcare organisation or hospital. Next slide, please, Tegan. So for a while, this area of law was subject to quite a lot of confusion. But then in the case of Ademaco, in the early 1990s, it was confirmed that actually to be liable for gross negligence manslaughter requires merely negligence, albeit of a gross nature, and not recklessness. Because in previous cases, there'd been confusion about whether the standard of fault required was recklessness rather than gross negligence. And the House of Lords, which was then the highest court in England and Wales, said that the essence of the matter is whether, having regard for the risk of death involved, the conduct of the defendant is so bad in all the circumstances as to amount in the jury's judgment to a criminal act or omission. Next slide, please. And this offence has been criticised for being rather circular in relation to that question about, well, do you think this conduct is so bad that it ought to be regarded as criminal conduct? And that's very confusing for juries. Also, there's an aspect of moral luck where only mistakes leading to the death of a patient will become subject to investigation and prosecution. There's also a tension on whether there'd been a sharp rise in prosecutions or not. And there's some sources there if you're interested in following them up, but I won't talk about those now. Next slide, please. So more recently, we saw a couple of convictions that came to great sort of public and media attention. One involved the conviction of a very highly respected colorectal surgeon, Dr. David Selou. And then the second one there, the conviction of Dr. Hadiza Bawagaba in 2015. And both these doctors were subjected to sort of systems and organizations where lots of things were going wrong. There were clearly systemic errors. Other healthcare professionals were at fault. Nevertheless, these individuals were convicted, although David Selou ultimately had his conviction overturned on appeal. So this led to a review, a government-commissioned review led by Sir Norman Williams in 2018. And around the same time, the GMC also reviewed the law on gross negligence manslaughter. Next slide, please, Tegan. And so we've seen since the review and the criticisms that arose a kind of retreat of the reach of gross negligence manslaughter, and a series of cases heard in the Court of Appeal have essentially restricted the way that this offence can be used against people, and particularly some of the sort of limitations that have been imposed in these cases, because this is an area of common law where judges in the highest courts basically refine the principles and sort of determine or redetermine what the parameters of this particular offence are. And this has made it, I think, much more difficult to find healthcare professionals responsible when they make mistakes leading to the death of a patient. Next slide, please. So other examples of the criminal law evolving, and in this case expanding, came as a result of the scandal at Mid Staffordshire Hospital back in the early noughties, and the subsequent Francis report led to some legal changes, including the expansion of an offence that previously only existed in relation to patients who don't have capacity. And we see an example here of two women who were convicted in March this year of treatment and willful neglect because of the abusive care that they perpetrated against a resident of the care home facility where they were working. Next slide, please, Tegan. Another way that the law has essentially been expanded, although in reality this is a very old law, we saw with the conviction of two surgeons in 2017. And if you're interested, I've written an article on this, which is open access, so you can just look at this without having a kind of a university library. If you could give me the next slide, please, Tegan. So this law dates back to 1861, and within that very large piece of criminal law, there are offences that capture non-fatal offences. So you will have heard of these things like GBH with intent, wounding, etc. And there are also some common law principles developed by judges as to when harm caused should be regarded as legitimate and an exception to the application of the criminal law, or whether there ought to be potential criminal liability. Next slide, please, Tegan. So the first case here is, and the man pictured is Ian Patterson, who mutilated a very large number of patients. I nearly said students then, just in my university lecturer mode. No, we don't mutilate students if you come and study with us. But Ian Patterson did indeed mutilate he told many patients that they needed surgery when in fact they didn't, and they didn't have cancer. Other patients who did have cancer were given a discredited procedure that Ian Patterson was very fond of, that he called a cleavage sparing mastectomy. And as a consequence, he is currently serving a 20-year sentence after being convicted of 17 counts of wounding with intent to cause grievous bodily harm and 3 counts of unlawful wounding, which is the less serious version of that offence. And this led to inquiries. And the reason this is really interesting for people like me is that it was a novel application of the criminal law. So the Offences Against the Person Act had never before been used against a surgeon, because surgeons can usually argue that even if they harm patients and surgery goes very badly wrong, that it's proper medical treatment or reasonable surgery and not subject to the usual principles of criminal law. Next slide, please, Tegan. And then the next person pictured is another surgeon called Simon Bramall, who was also convicted in 2017. You might have heard of him. He used an argon gas coagulator to brand his initials onto the livers that he was transplanting into his patients. And this was discovered when one of the patients rejected the liver. It was removed, and the initials of Simon Bramall were therefore visible. And it was then discovered that he did this. The quote there is, apparently one of the theatre colleagues noticed what he was doing and asked what was going on, and he simply said, "I do this." He pleaded guilty and was convicted of assault by beating and fined £10,000. And eventually, after he was initially treated rather leniently at the Medical Practitioners Tribunal Service, he was erased from the medical register. Next slide, please, Tegan. So I'm going to skip over that because it's just an interesting quote. Next slide, Tegan. I don't want to run out of time in terms of allowing Sarah to talk to you now about the offence of corporate manslaughter.
Brilliant, thank you, Alex. So one of the offences that we're looking at, and this all relates to an article that Alex and I are developing. We're interested in your feedback on in the comments later. So one of the other offences that we're looking at explores a more systemic, higher level organisational responsibility for harm, and that's the offence of corporate manslaughter, which is found in the 2007 Act that's set out there. So the Act was brought about with the intention of enabling prosecution and accountability of organisations and the management level of those organisations for serious failings in health and safety leading to death. And the Act sets out the specific elements of the offence. So the organisation has to owe a duty of care to the person who has lost their life and to have grossly breached that duty of care. And the same challenges that Alex has set out in relation to gross negligence manslaughter arise in relation to this test here. The senior management of the organisation have to have engaged in activities that form a substantial element of the breach of the duty of care, which has led to the death of the person concerned. In relation to what punishments follow, because this is an organisational level offence, fines can be imposed, and importantly here, no maximum fine has been set in law, so these can potentially be very large. And also it's possible for remedial orders to be made, so requiring the organisation to correct the failings that have led to the death in this instance. And publicity orders can be made so that details of the organisation concerned and the actions that they took and the poor standards of care can be made available to the public. One of the challenges here is to identify the causation point in relation to the activities of the senior management. So in large organisations such as NHS trusts, you can imagine that it can be difficult to identify the particular steps taken that have a direct causal link to the death of the person. Next slide, please, Tegan. And because of some of the challenges that I've alluded to there, successful prosecutions in the healthcare setting are extremely rare. I've given you one example there, which doesn't relate to an NHS trust, but is in the care setting. And there an organisation was fined over £1 million in 2021. And this case related to a woman called Frances Norris, who unfortunately died as a result of the poor care she received. She was 93 at the time and living with dementia. and she was placed by carers in a scalding bath in her care home. And she died a few days later as a result of those terrible burns. Now, some of the factors that exacerbated how the actions of the defendant organisation was judged were that subsequent to the failings in care, records about Mrs. Norris's care were falsified by members of staff. So that really exacerbated how the poor light in which their actions were seen. Problems with the water heating system in the building, in the care home, had been known for a number of years, but nothing had been done to correct those. And so these factors were taken into account in determining that the organisation had met the threshold for that offence. 2 carers were given individual criminal sentences again as well. Next slide, please, Tegan. Now, I mentioned that it's very rare to succeed in prosecutions of corporate manslaughter in healthcare, but there are large investigations in relation to this offence, in relation to NHS trusts going on at the moment. So the Countess of Chester Hospital, where Lucy Letby was working, is under investigation for corporate manslaughter, and that was recently announced, as well as gross negligence manslaughter investigations going on. The North East London Foundation Trust is currently on trial in relation to a corporate manslaughter offence, and this relates to failings in care in relation to the young woman we see here, Alice Figueredo, who died by suicide at a hospital while she was an inpatient on an acute psychiatric ward. And there it's alleged that there was a failure to remove potentially harmful items that it was known that Alice would try to use to end her own life. And there is a concurrent trial in gross negligence manslaughter in relation to the ward manager there. Next slide, please, Tegan. And there's a large investigation going on called Operation Bramber in relation to the Sussex NHS Foundation Trust, which again combines investigations into corporate manslaughter, individual manslaughter offences in relation to at least 90 patient deaths at a Brighton hospital between 2015 and 2021. Non-fatal harms are also being considered as potentially falling foul of the criminal law. One of the cases here relates to the man that we see there, Richard Harris, who died after extensive delays and failures to refer in relation to his cancer treatment. Interestingly here is a feature that can sometimes occur in relation to exceedingly poor care, which is the actions of whistleblowers. So the alarm was raised in relation to the Brighton case by 2 clinicians relating to care in neurosurgery and general surgery that they were really concerned about. But in an unfortunate turn of events that does seem to be a repeating pattern again, both have lost their jobs subsequent to raising the alarm. Police have asked for more resources from the Home Office to undertake this extensive investigation, and that's ongoing. Next slide, please, Tegan. Now, I mentioned that it's rare that these prosecutions are undertaken and are made out in the NHS context. And that's because of the complexities of the constituent tests of the offence. So causation can be really challenging in a negligence context anyway, particularly in the healthcare setting where we're dealing with potentially very poorly patients anyway, and it can be hard to distinguish between the causal effects of their underlying ill health and the causal effects of poor care on their resulting death. And causation is the challenges are exacerbated in a corporate systemic context, as I mentioned, because it can be hard to determine which decision at a senior managerial level was the causal aspect of the loss of life there. Alex has talked about the challenges in defining and making decisions on the test of grossness as well. There are some really serious issues, as we've seen, particularly in the Brighton case, where the police are asking for more resources in relation to cost. And there are significant delays in investigating corporate manslaughter offences. These are offences of high complexity, with a real need for expertise in relation to determining whether or not it's likely that the offence has occurred and trying to make that out. What we've seen from previous cases of corporate manslaughter more generally is that if there is a pattern of behaviour that amounts to existing poor levels of care, as we saw in relation to the care home case, that can increase the likelihood of a successful prosecution. But it remains to be seen whether that can be made out in the context of a hospital setting. There are interesting questions that Alex and I are exploring about corporate manslaughter and its purpose here in the healthcare context. So what is this offence for in that context? Is it punishment? And if so, are fines helpful here? Is the punishment aspect of the offence going to be helpful, where there might be a turnover of individuals at senior management level, and so when finally a fine is imposed, those people may have moved on? Another of the questions that we're asking is whether such offence actually serves to incentivise higher standards of care. Does it actually have that effect? This is something that we're exploring. Be interested to hear any views you might have on that in the Q&A. One of the potentially really useful aspects of this offence is that it can overcome some of the problems that we have identified in relation to trying to focus on individual clinicians or practitioners in relation to failings in harm. So it can have benefits in trying to look more broadly and beyond the final actions of the clinician to explore and overcome poor organisational systems. So that could be a potential benefit there. Next slide, please, Tegan. So as I mentioned, Alex and I are trying to explore some of the conclusions that we can come to in relation to the role of the criminal law in the healthcare context. In relation to thresholds of meeting offences, there can be discrepancies across the offences. So in the gross negligence manslaughter context, we have seen examples of practitioners who have been trying their hardest in really challenging circumstances and have been identified as individually responsible without those wider circumstances being taken into account. And we've seen other examples of practitioners who seem to be engaging in persistent levels of poor care, but that goes on for a long period of time. And what is it that is failing to happen there to prevent that? We're interested in exploring this tension and relationship between scandal and the law's response to it. Is scandal a good impetus for bringing in new offences or using existing offences in a novel way? And we're also always interested in exploring questions about moral culpability, whether that's at clinical, clinician or practitioner level or amongst the levels of managerial responsibility. Next slide, please, Tegan. There are some themes emerging more broadly that we're also exploring in our work. One of them is whether something called medical misogyny is in play here or exists at all. We want to explore whether women are more likely to be seriously harmed by healthcare practitioners, such as shipmen, and what might be at play there. And this relates to some wider work that we're looking at in relation to levels of care provided to women in the maternity context, for example. We also think it's really important where the criminal law is being used to be very clear about what the purpose of trying to explore whether individuals have committed offences. What's the purpose of doing that? Is it to deter? Is it to improve standards of care? And if so, is there really a mechanism amongst these offences for learning from error and closing that circle of exploring what's happened and improving care and standards? So next slide, please, Tegan. So we've given you a lot of information there about the role and the use of the criminal law in their healthcare context, and some indications of some of the questions that that we're exploring ourselves. So we'd be really interested to know whether you have any reflections on that. It's something that we presented recently also at our current distance learning students away day, and it was interesting to hear the perspectives of practitioners from legal and clinical fields on the use of the criminal law in the healthcare setting. So thank you for that.
Thank you, Sarah, and thank you,
Alex.
Yes, we've got a few questions coming through, so thank you both for putting so much information in such a short space of time. You can see some questions and a few comments coming through. So what we'll do is we'll go through some of these questions, and then I'll give a little bit of detail on the course, and then you can have the chance as well if you've got some questions about the course specifically as well. I can see there's a few questions just in general about kind of getting the slides and information after the session. What we do is we'll send you'll receive an email probably next week with the recording and details in that, and then we'll also include any links that were in the presentation in there. So I know someone's mentioned about being able to follow up on the cases. So within that email, you will get the details of those links that were in the slides as well, and the recording, just to answer those two questions there. And then another question that we have had through, so I don't know if Sarah or Alex wants to take this, but I'll let you both decide. But it was the duty of care extend to any patient who experiences errors in their care by the organisation that did not lead to the death? I'm not quite sure.
Yeah, so that's a really interesting question. All patients benefit from a duty of care in relation to their health care, and that duty of care is a reasonable standard of care. So it's not a Rolls-Royce standard, it's the reasonable level of care that would be provided by a reasonable and responsible body of practitioners within that area of care, so whether that's surgery and so on. So we've spoken today about some offences that relate to loss of life, but obviously there are also duties of care in relation to patients who experience poor care but don't lose their life but suffer another type of injury as a result of that. And the criminal law and civil law both look to those.
Thank you, Sarah. We've had another question is, thank you for the insightful presentation. Would you argue that it's easier to regulate private healthcare or organisations such as the National Health Service?
Gosh, that's a hard question. I mean, I think evidence looking at the case particularly of Ian Patterson suggests that there are very serious problems and challenges in regulating both private and NHS care, and very sort of different things went wrong. Looking at Ian Patterson's case, and obviously this is, going back more than a decade, where he committed his crimes from about 2009, no, actually more than mid-noughties, until he was sort of eventually stopped in about 2015, 16. But the problem with the private provision in relation to his activity was that it was basically the private hospital treated it almost as private surgeons can come in and they're almost like renting a room, and there was no kind of oversight of what was going on. And the fact that they were also working in the NHS was taken as kind of enough for the private organisations to feel satisfied that there was, you know, nothing, that they were safe, basically, which was obviously a serious error. I think in relation to the organisational, disciplinary and regulatory tools within the NHS, I mean, there are sort of clear examples of what might be done, and reading the report carried out by Reverend James on Patterson's case was really interesting, because I think what was happening was there was a sense that people knew what was going on within the NHS hospital where he was working, and they did try and prevent him from harming patients, but they didn't do enough. And he was quite a bullying character. People were frightened of him. People that raised, you know, who were whistleblowers effectively, were often ignored and belittled by the management. You know, we've sort of seen different but you know, similar issues arising out of the Lucy Letby case, where it's really difficult for colleagues who see that a certain person is not safe to raise concerns to the management.
Shall I take the next one, Tegan?
Yeah, great, yeah.
These are all really great questions. Thank you so much, everybody, for reflecting on these. So Nicola's question: the medical examiner service was developed as a countermeasure after the Shipman inquiry. What impact, if any, do you think their scrutiny could have on securing prosecutions? Serious issues have been highlighted by medical examiners before, where then the coroner decides against an inquest, which leads to the issue being left to be managed internally. That's a really interesting question, and there were quite a few structural changes brought in after Shipman, including revalidation and so on, in this effort to increase oversight and transparency and standards. Just because the coroner has made a specific decision doesn't mean then that a criminal prosecution or investigation is ruled out, and police investigators can take into account a wide variety of evidence in relation to the specific incident, and also in relation to more general standards of care, you know, to establish whether or not this seemed to be a pattern of poor behaviour. So it doesn't necessarily rule that out. And there's a similar question there by Jenny Morris, which relates to this, talking about themes leading to learning from error. One issue we have in clinical work is regarding the DATIC system and how it's not used effectively. What role does such a system have in feeding into prosecutions? Do they have standing in law? And how can the use of it be improved without fear of whistleblowing or assigning blame? Those are really interesting and important themes. And I think it's probably helpful for people who are trying to make recordings about standards of care or failings or near misses and errors, where there are any concerns about that, to take advice from the local Freedom to Speak Up Guardian. Again, there's no particular barrier around the evidence that police can take into account when exploring particular offences, and so it's probably important for practitioners to feel safe and comfortable about that. And it might be that using such a system is actually easier than making an individual whistleblowing step, taking that step, but always take advice either from your defence union or from the Freedom to Speak Up Guardian if you have any concerns about that. I think there's some more questions coming in.
Yes, we've got quite a few questions coming through. So I don't know who wants to grab which one, but someone's asked, can human error without proven intent of harm result in a criminal offence?
Yeah, I can answer that. Well, I think in reality that it's very unlikely that that would happen. But the offence of gross negligence manslaughter in the case where a patient dies as a result of serious error doesn't require that there's any intention to cause harm. It just merely requires that the person who caused the harm, who killed the patient, showed a very, very high level of gross negligence. And negligence is kind of defined as like a failure to do what you should have done in a situation where there was a serious risk of death. And the healthcare professional should have realised that. But in reality, since the Court of Appeal decisions that I touched upon, unless a very, very serious error has been made in a situation where it's just absolutely, shocking that a person didn't realise that would be a catastrophic error, I think it's almost certainly very unlikely to lead to a prosecution for gross negligence manslaughter. And the other offences that I talked about, so for example, wounding and causing GBH, they do require a sort of high level of recklessness or intention to cause that serious harm. So I hope that answers that question.
Thank you.
Thanks.
And then there's another question here from Andrew regarding corporate manslaughter cases. Is there an upper limit? For example, can an NHS trust deflect a case against them to NHS England or the Department of Health on the grounds of systemic failures associated with funding deficits or national policy level decisions? I can see where you're going with that, Andrew. It's an interesting question. The starting point for the corporate manslaughter cases is whether a duty of care is owed, and it's important to look at what that duty of care is, so its extent and its focus. So traditionally speaking, the courts have been reluctant, certainly in the civil arena, to find an existing duty of care to overcome systemic failings, but that is expanding a little bit now. In terms of the question about funding, the courts have also been very reluctant to litigate over decisions that are making about funding. So the duty of the Secretary of State for Health is to provide some funding. Once that's done, how it's allocated and so on is something that the courts don't particularly want to interfere with. So it's probably unlikely that can be pushed upwards. And also there's a challenge there in terms of the mechanism. So it would be for the police to identify where that responsibility lies, rather than a trust being able to suggest that they direct their investigation elsewhere. But there are obviously really important issues and links between challenges in funding and resources and the standard of care that can be provided. And so I'd agree with, what I think is the theme perhaps behind your question, which is that seems a little bit unfair to provide individuals and organisations with the responsibility to uphold standards when there's an under-resourcing. So it's an interesting question.
I think thank you very much for that. I think in the interest of time, I hate to be this person, But what I'll do is I'm just going to do a quick little overview of some of the course information. In the meantime, while I go through that, if Sarah and Alex, you want to pick a question each that we can then come back to, because I think we might only have time for sort of 2 more questions that can be covered, whilst I just give a course overview. And I know there's some great questions in there, so like I said, I hate to be the person that calls the time, but we just want to make sure we do cover everything. So with that said, I know on the call we've got a mixture of people that have already applied and some people that haven't yet applied and still thinking about it. Our course website, our course webpage and the course brochure are really great sources of information. So if you haven't already had a detailed look on there, please do. There are different qualification pathways for healthcare ethics and law online, and I specify online because today we are talking about the online course, so there's no requirement to be on campus for this course. It is delivered asynchronously, and you do have the options of an MA, LLM, PG DIP, and a PG Cert in Ethics and a PG Cert in Law, as well as a CPD. So there's lots of different options available. I'm not going to go into sort of all the entry requirements for the course because it does vary depending on what kind of route you're going down. But the majority of the courses do start in September on the 15th. And the PG Cert in Law is slightly different because it has a January start date, whereas the CPD you can enroll in that at any time, so it's a little bit different again. There are no sort of exams in the traditional sense on the course, so it is all coursework based, and dissertation project is required as well. Again, sort of different requirements for each course, so that's why I've not gone into too much detail because I don't want to confuse you there. But for the ME and the LLM, there is a dissertation project. For the other subjects, you wouldn't need a dissertation. In terms of fees, you can see that the fees are displayed on the screen now as well. And we do have a number of different discounts available. So if you do have a look on our website, you can see the details of kind of eligibility on what discounts would apply to you. So for example, we do have an NHS employee discount where we would require sort of some proof and confirmation from your employer that you are an NHS employee. We do have an application discount, which if you make your application before the 30th of June, then you are entitled to a slight reduction in those tuition fees as well. And we do have different alumni discounts available. So do have a look on the website and for more details about them. We do have a 1 discount policy, so it's usually that if you're eligible for 2 or 3 discounts, you'd get the higher one. So please do have a look on that. And also, because like I say, it can be quite confusing because there's so many different sort of qualifications available. You do have the opportunity, if you want to have any like one-to-one consultations with myself, you can book that with me, so that's not a problem. So you can contact me on studyonline@manchester.ac.uk if you do want to kind of just get a bit more information about the course, or just in general about sort of the application process or anything like that. It is free. It's usually about 30 minutes, and it's just a chat with me to kind of go through the sort of different routes that you can take, as I'm very aware from conversations I've had with other people that some people are they know exactly what route they want to go down, some are still a bit unsure. Applications are still open, so you still do have plenty of time to apply, but I do know sometimes an additional conversation can be beneficial. So that's just a little bit of course information, and like I say, please do visit the website, do download the course brochure, and do get in touch if you do have any more questions. With that said, as I mentioned about time, we can probably fit in just 1 more question each. I don't know if Sarah or Alex, if you had time to decide the question that you'd like to answer.
Yeah, well, I noticed a couple of people asked about sort of opportunities for sort of linking people with firms and what opportunities are after graduation. We do have sort of lots of opportunities on campus to kind of engage with. We have like employability activities. We've also got a free legal advice centre where students can take part in real pro bono work supporting people, and some of those people might have problems that relate to provision of healthcare and things that fall within the domain that you'd be studying. But there is also, importantly, a really incredible careers team at the University of Manchester, and that is available for all students. So even if you're never in Manchester and you don't need to come in and physically be here to get the help and support of the careers people, and they are really excellent. So you'd also get a personal advisor who would be able to talk to you about any sort of opportunities and possibilities to like go in a new direction or use the qualification in a really meaningful way to develop your career. So that support is there. I think that's obviously important. So that's the question I've chosen to answer.
Thank you, Alex. And just to add to that as well, as Alex mentioned about, you know, having support with the career service, also other services that are available to our on-campus students. So whether it's student support, library services, that you still have access to that. It's just in, you know, there's an online format and the different ways to communicate that. So please don't think, you know, because you are online, you don't have those same access that on-campus students do. You will, and you will get more information about that as well.
Okay, so I'll just really quickly respond to one final question as well, which is from Pete. Do you think there's a disparity in the outcomes of harm caused to patients in mental health care versus physical health care, especially due to issues such as capacity and voluntary treatment and the acceptance of harmful restrictive interventions? This is a really interesting question, and it is interesting that in addition to units providing healthcare to women as a group, for example, those providing healthcare in relation to people who have mental health needs have also featured quite heavily in the scandal category. So it does seem that there might be something there. And there's a debate about whether patients are vulnerable. Some people say that they are just by their very nature vulnerable. There are some people will argue that that's disempowering to say that patients are vulnerable, but it does seem that those who are receiving care, particularly inpatient care for mental health needs, have been subjected to poor levels of care in some of the inquiries that have come out and highlighted particular themes in relation to that group. So that's a really interesting question as well. Thank you.
Thank you. So thank you very much, everyone. I'm very sorry we couldn't get through all the questions. There's just too many very good questions there for us. But thank you for your contribution as well. It does help, and you know, it's great to have that conversation and the discussion. That's what we want from these events as well. Thank you to Sarah and Alex for taking the time to be here today. It's very, very much appreciated. And as I said earlier, you've spit so much information into such a short space of time. So thank you again. You will see a poll on your screens now. So if you do have a chance just to answer those feedback questions, that would be much appreciated. But all I can say is thank you very much and take care and enjoy the rest of your day, end of your day, wherever you may be. And please, if you do have any questions, don't hesitate to get in touch because the contact information is still on the screen. But thank you very much.
Thanks, everyone. Thank you to you as well, Tegan.
Thank you, Tegan. Thank you, everyone. Nice to see you.